Good day, ma'am. I am Aivan Frogosa from Block 2. My report is all about Section 10 and Section 11. Section 10, Law on Speedy Trial Net A bar to provision on speedy trial. In the Constitution, no provision of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Section 14 to Article 3 of the 1987 Constitution, Section 15. The constitutional right to speedy trial as guaranteed under Section 14 to Article 3 of the 1987 Constitution takes precedence over any statutory law or implementing rule on the matter of speedy trial. No provision of law on speedy trial and no rule implementing such laws can be interpreted as a bar or limitation to the constitutional right to speedy trial. In other words, the constitutional guarantee of the right to speedy trial cannot be restricted, diminished, or negated by any ordinary legislation or administrative rules on speedy trial procedures. So that the constitutional right to speedy trial is a fundamental right that stands on its own and cannot be undermined by any statutory enactments. The constitutional provision is the primary and supreme source of this right, and it cannot be overridden by any lower level laws or rules. So, Section 11, Order of Trial. The trial shall proceed in the following order. A. The prosecution shall present evidence to prove the charge and in the proper case, the severability. The prosecution has the burden presenting evidence to prove two things: the criminal charge against the accused and the severability if applicable. In other words, the prosecution must present efficient evidence to establish the guilt of the accused with respect to the criminal offense charge and to prove any severability that may arise from the criminal act, so that the prosecution has burden of proof in criminal case, both for the criminal charge as well as any related severability. They cannot shift this burden to the accused and must present the necessary evidence to prove their case. Letter B. The accused may present evidence to prove his defense and damages if any arising from the issuance of a provisional remedy in the case. The accused has the right to present evidence for two purposes: to prove their defense against the criminal charge and also to prove any damages they have suffered is as a result of the issuance of any provisional remedy in the case. In other words, the accused has the right to present evidence to defend themselves against the criminal charges. The accused can also present evidence to prove any damages caused by provisional remedies issued in the case. Letter C. The prosecution and the defense may, in that order, present rebuttal and rebuttal evidence unless the court in furtherance justice permits them to present additional evidence bearing upon the main issue. The presentation of evidence in trial. The prosecution and the defense have the opportunity to present their respective cases in the structured manner. The rebuttal and rebuttal stages allow the parties to directly address and respond to each other evidence. The court has the discretion to allow additional evidence if it is necessary to achieve a just outcome. This process ensures in fair and comprehensive presentation of evidence, allowing both the prosecution and the defense to fully argue their positions before the court. Letter D. Upon admission of the evidence of the parties, the case shall be deemed submitted for the decision unless the court direct them to argue orally or to submit written memoranda. The submission of a case for decision after the presentation of evidence. Submission for decision after the evidence has been presented and admitted, the case automatically considered submitted for the court's decision. And the discretion of the court has the discretion to require the parties to further argue the case, either orally or through written memoranda, written submissions rather. This allows the court to obtain additional clarification or arguments from the parties before rendering its final decision. The court can exercise its discretion to have the parties further elaborate on the evidence and legal issues if necessary for a well-informed decision. Letter E, when the accused admits the act or omission charged in the complaint or information but interposes a lawful defense, the order of trial may be modified. Admission of the act or omission. The accused acknowledges that they committed the act or omission that forms the basis of the criminal charge, interposing a lawful defense. Despite admitting the act or omission, the accused claims that they have a valid legal defense that should exculpate them from criminal liability. Modification of the order of trial, given the accused admission of the act or omissions, the court may modify the normal order of trial proceedings. The modification may involve, for example, the accused presenting their defense evidence first before the prosecution present its case. This allowed the court to focus on the legal issues surrounding the accused defense rather than spending time on establishing the basic facts of the case.